questions from the committee. Senator Sampson.
Thank you, Mr. Chairman. And through you, I just have one very simple legal question. Just listening to your testimony and the response to one of the earlier questions, it was your testimony that the passage of the constitutional amendment would not interfere with the laws that are currently on the books. But then later on in your testimony, you acknowledged that while it might not immediately have that impact, that future action might indeed require the legislature to act. So I guess my question is, will you acknowledge that this constitutional amendment may in fact, if passed, result in a court determining that our existing laws on gender, surgery, abortion, etc., could be challenged in the court and overturned? Through you, Mr. Chairman.
Thank you so much for your question, Senator Sampson. That is not what I said, actually. What I said was that if there were any further changes that folks wanted to make, that there is a process that we have in Connecticut, a regulatory process, a legislative process that we would have to go through. That is not a process that is automatically triggered by this constitutional amendment. So I just want to make that clear.
I appreciate that answer. Through you, Mr. Chairman. Okay, but maybe I misheard you, but my question still stands, which is, does the passage of this constitutional amendment create a situation where an existing law could be challenged in court and have that law overturned? Through you, Mr. Chairman.
Thank you so much. My answer remains the same. Thank you.
And what is that answer, through you?
The answer is no. Thank you.
I appreciate your answer, but are you not aware of situations where constitutional amendments have changed and overturned existing statute? Through you?
I am, and in those particular instances, some that we do reference in our testimony that I would love to refer the committee to, the way that this constitutional amendment has been written, it is very intentionally not doing that. It is very intentionally clarifying existing protections that we already have on the books. It is not invalidating anything that we currently have on the books either. There is no Connecticut law that is invalidated in the way by the way that we have written this amendment.
Thank you for that. Through you, Mr. Chairman, the way I read the amendment is that it would effectively allow an abortion at any point for any reason, even up to the moment of birth, because it says, I don't have it in front of me, but it says any potential termination is covered and protected as a matter of right. Do you agree with that?
The current viability ban that we have on the books, that is not something that this amendment would immediately change. It doesn't trigger unconstitutionality of that at all. And as Liz Gustafson said from Repro Equity Now earlier in her testimony, abortion, late-term abortion, those are also very much inflammatory terms that we reject in terms of framing. Thank you.
Through you, Madam Chairman, forgive me, I didn't understand what I said that was inflammatory. I'm just trying to be as delicate as I can, and I'm trying to get to some clarity on this subject. You know, this is a very frustrating conversation because, you know, anyway, the fact of the matter is that the constitutional amendment that is before this committee that we're debating and people are testifying on is extremely broad. It does not make any specific requirement for viability. In fact, it ignores that entirely. So if the concurrent state statute requires viability, this does not. And based on that, I would say that that would put that particular state statute in doubt. And it's even more obvious when we start talking about the subject of gender reassignment surgery, because there are certain things that are not allowed in Connecticut statute by any stretch of the imagination that are broadly covered in this. It says no person shall be denied the equal protection of the law, et cetera, as used in this section, discrimination in the exercise and enjoyment of civil or political rights because of sex. And then it says includes pregnancy, including preventing, initiating, continuing, or terminating a pregnancy. And that means for any reason. It doesn't say for good reason or bad. And then it says sexual orientation, gender identity and expression, and related health care, which is the broadest possible term. We heard for testimony earlier from someone who is an expert in this area because they actually worked in a medical clinic where they perform these surgeries, and she's suggesting that all of it's coming back now. And there are people that have been harmed by this, and the concern is that down the road, those people need a cause of action to be able to sue the medical providers that harm them. This would protect those medical providers. Is that correct based on the language that I'm reading? It seems that way to me. Through you, Madam Chairman.
So I want to also be very intentionally clear that Jess and I, as I said before, are both attorneys who have done sound legal analysis on this. And so any assumptions that this would do something or wouldn't do something, we've made very clear what it would and would not do. As far as the point that you made with regard to our viability ban and the actual language that is used in terms of the terminating of pregnancy, again, we already have state law statutes on the books, and this does not interfere with those. And I mean, I think we've been very clear in that we've done our due diligence as constitutional scholars in ensuring that we can speak to that. So thank you.
Thank you for that answer. And through you, Madam Chairman, well, I guess we'll just leave it with this question then. Can you just clarify that you are not a judge and that what you're offering is nothing more than your legal opinion, which many other attorneys may in fact disagree with? Through you, Madam Chairman.
Absolutely. I am not a judge. I am an attorney, as Jess is. And my understanding is that the majority of testimony has supported exactly what we've said several times here today, that this does not change or repeal or alter our existing statutes in any way. It simply clarifies protections that we already have on the books.
I want to just thank you very much for your testimony through you, Mr. Chairman. I appreciate you being here. I enjoy the conversation with you ladies. I don't know why it turned into something that had to be hostile. I've really got no idea where that came from. We're working completely towards a solution and looking out for the interests of people in this Connecticut, the state of Connecticut. I can assure you that the people that will ultimately not support this amendment as it stands are certainly not interested in harming anyone or preventing anyone from having particular rights or discriminating against them. It's a matter of, we think that it's good or bad policy for the state of Connecticut. And I'm concerned that writing such a broad amendment is going to end up with a negative impact and not a positive one, even for the people that you're here advocating for. Thank you, Madam Chairman.
Thank you so much. And I would like to just say that it is in fact harmful to insinuate that I am being hostile as a Black Puerto Rican person before you. So I would say that that very incorrect misconception in and of itself is very problematic, and I will implore us to be very intentional about the language that we use. Thank you.
Senator Sampson, did you have a question?
Thank you, Mr. Chairman. I just want to clarify that no one said you were being hostile. I didn't use that. I said that our conversation seemed hostile. Okay. You suggested that things we said were inflammatory, et cetera, and I don't believe they were. I think we were trying to be as polite as possible. And I'm suggesting that this should be a polite conversation, as I mentioned, from the start of today. There's no reason to be angry about anything. We can disagree and still be friends. We really can.
Thank you.
Thank you, Mr. Chairman.
Thank you, Senator. Representative